Hello, and welcome to this week's Ask an Atheist. My name is Liz Cavell. I'm Associate Counsel for the Freedom from Religion Foundation. I am joined today by attorney Kat Grant, who has a fellowship here at FFRF through Equal Justice Works. And we're joined remotely by our senior counsel, Patrick Elliot. He is joining us from Minnesota. Hi, Pat.
Glad to join you. And today we're going to discuss the latest Supreme Court case that was just argued on Monday, actually. So this is all very fresh, where a business owner is challenging an anti-discrimination law because she claims her religious beliefs grant her an exemption in order to discriminate. And we're going to break the case down for you and talk about how the arguments went this week.
Yeah, that's right. We actually talked about this case way back when the Supreme Court announced that they were going to hear it this term. And again, oral arguments took place on Monday. All three of us listened and have some definite feelings. And as always, if you have questions about the topic today, you should drop them in the comments below, or you can send an email to askanatheist@ffrf.org. We'll try to take your questions at the end. Patrick, so before we get into the oral arguments at the Supreme Court and how that went, why don't you just remind our viewers what's the background on this lawsuit?
Yeah, we have talked about this before, but I think this will at least give a little basis for the arguments, which were kind of all over the place. Lori Smith is a Colorado business owner. The business is 303 Creative, and she does some graphic design and some website design. She doesn't actually design wedding websites yet. She claims she wants to do that, and she claims that Colorado's law, which is an anti-discrimination law, would prohibit her because her religion would not allow her to do any websites related to a same-sex wedding. And in fact, she wanted to post a disclaimer, which she provided to the court. This is an example of what her wedding webpage would look like. So this is all fake. It's not a real website. And her disclaimer would really say, go into some detail about how she could really only do, let me see if I can pull up some of the language. I will not be able to create websites for same-sex marriages or any other marriage that is not between one man and one woman. So that's what she wants to put on her website. It's pretty clear she's not going to provide this service to same-sex couples and anyone else that she deems to not be fit for her services. So she sues kind of preemptively. Again, there's been no enforcement against her. She's never done a website like this. She sues the state of Colorado, Colorado officials. She loses in the district court. She loses in the Court of Appeals. And to no one's surprise, our Supreme Court takes the case. And they took it as a free speech issue. They ignored the free exercise religion issue, but obviously these are kind of concepts that are tied up together. FFRF filed an amicus brief or a friend of the court brief in this case. And one of the things we pointed out, which I think is kind of front and center in the arguments, is how manufactured this is. And so one of the parts we say, Lori Smith may dislike that loving same-sex couples in the United States are afforded the right to marry. Her religious disagreement with marriage equality, however, does not magically transform a speculative chain of events into imminent injury. 303 Creative has manufactured a controversy and cannot demonstrate that it is under the threat of enforcement of the Colorado Anti-Discrimination Act. And why that matters is there's been no facts of this being applied against her in any way. So unlike the Masterpiece Cake Shop case where you did have an actual dispute between parties that went through a administrative process, this is all made up, at least how it's been presented to the courts. And so that's why I think the arguments were kind of all about hypotheticals this week. And it was a little bit bizarre listening to the arguments because there's not a lot of talk about what Lori Smith was actually doing with her websites. So that's really the case background that will lead us into the arguments by the court.
So just to drive home the point on why the posture of the case at pre-enforcement is so weird. It's like this is just kind of American courts 101, but when we are asking judges to weigh in on our disputes, the whole deal is that it's supposed to be for things that have happened and injuries that have been caused because of the government's action or inaction or something. Like the person, the plaintiff bringing the case, is supposed to have suffered some harm, some injury that can be addressed by the courts. That's just kind of the basics for getting into court. We don't ask our courts to say like, hey, I really want to do this thing to my neighbor, and I'm not going to do it yet, but I want to do it. I feel like the law might be preventing me from doing it. Court, I want you to tell me it's okay. That's not really how we are supposed to be utilizing our courts. That's what's going on here. There's this manufactured plaintiff who is saying, I want to do this. I don't currently do it. I haven't been punished for doing anything. The state of Colorado hasn't enforced the law against me, and I don't even do the thing that is subject to enforcement. But I want to, and I want the court to sort of give me its blessing. That is an odd posture because there's no facts below for the court to evaluate. And as we'll talk about in the argument, that was a central feature of the arguments. It was kind of just like the battle of the hypotheticals. Well, what if this? And what if this happened? And what would you say if this happened? And even the whole entire case, as Patrick's pointing out, itself is a hypothetical situation. So like we said, the case was argued 2 days ago on Monday morning. So everyone, I think, is still digesting the argument and what we heard and what it meant. But let's get some takes. Kat, you listened to arguments. They went really long. It was over 2 hours and 20 minutes, which I think they were scheduled for like 70 minutes. So it was long. What was your sort of just overall reactions? What were your hot takes?
So here's the good news. It wasn't worse than I was expecting. Here's the bad news. I am prone to catastrophizing. So I was expecting it to be pretty bad. And I think the thing I kept coming back to, I mean, we've already mentioned it several times. This was wholly manufactured. This is not a real situation that is happening. And it was, I hate to say it, a brilliant piece of strategy from ADF because there's no queer couple on the other side. There is no same-sex couple for people to sympathize with.
Right.
There is no one who has been turned away, who has had to face that indignity of being told, sorry, you're a second-class citizen, you can't access what everybody else gets to access. And so that was really brilliant strategically in my mind, because in the American psyche, the government is never the good guy.
Right.
So if you're suing the state, that already puts you in a position of being like, I'm the victim, I'm very sympathetic to a lot of people, especially those people who are on the fence. So I think that was really the thing I kept coming back to, is no one is telling the story of the LGBT people, of the same-sex couples on the other side of this, of the people who are actually going to be hurt and not just speculatively hurt.
Right. That's such a good point. Patrick, what was your sort of gut reactions, first reactions to what we heard on Monday?
Yeah, I mean, it kind of hammered home, like, why did the Supreme Court take this case? They get over 5,000 petitions per year, and maybe, I think last year took like 60 cases. So they're using a very small docket to take this case. And for the reasons we've explained, and I think listening to the arguments, it seems so apparent this never should be there. But it really felt like, in observing it, that it was a bunch of law professors discussing like the intricacies of free speech and what might happen if, somebody was required to do something. And I think that is really bothersome to listen to as a First Amendment attorney, because we're obviously sometimes taking free speech cases, but these are real cases. In our case, if we were to bring it, it would, get kicked out of court because they'd say, well, you haven't shown direct injury, or this case isn't ripe yet because it hasn't actually been enforced. And I think they got a total pass. So that was frustrating to hear that we were all in hypothetical land for the whole entire argument, I would say.
Yeah. Same. I mean, and Kat, that's such a good point. It's like you're not actually hearing the full context of what is being asked of the court and how this issue affects the American people. Like, what the court is inevitably going to do here is undermine civil rights protections for all of us that live in states that are trying to protect our civil rights, like the state of Colorado. And so you're not hearing that other side of the story. You're just hearing what the Supreme Court majority wants to highlight, which is, and we've talked about this in other cases, this Supreme Court majority is as extreme as we're all saying, and it does have as much of an agenda as we're all saying. And that agenda is highlighting the favored Christian litigant and portraying them as a persecuted sector of American society, and remaking and reshaping First Amendment law to favor Christian litigants and Christian people. And I think that was really prominent in the questions that were framed by different justices. And so we have some clips, Pat. I think we should get to them because it was pretty interesting. Why don't you set up some of the clips?
Yeah, so first off, I think we have Justice Sotomayor, who's my favorite justice, kind of digging in on what is the speech that we're talking about and who is it attributable to? Is it attributable to the person who made the website or the couple who's, inviting people to their wedding?
But I looked and to your proposed website, and I turned to page 51. It says, save the date, Lily and Luke, November 17, 2017. So what's the message if it says save the date, Lily and Lillian, or Lily and Marion? What's the message there?
That's an invitation to celebrate a marriage.
But why is it your invitation? I go to a wedding website. It's something that I send, meaning you, your clients. I send it to my family and friends, or Lily and Luke send it to their family and friends. You don't send it. They go to this website. You're not inviting them to the wedding. Lily and Mary are. So how has it become your message?
In the same way that it is the message of a ghostwriter who writes an anonymous press release or a book, it is still that writer's speech.
Right. So go ahead, Pat.
I just thought it was interesting, this is kind of early in the argument. So kind of starting off with, what are we talking about? What does this website, proposed website look like? And who can we attribute it to? And so I don't know, I kind of thought it was bogus, the equating it to like ghostwriting a book. And I don't know, how you all felt about the, Sotomayor kind of going down this line of questioning.
Yeah, I mean, so it's important just to break it down to like the layperson level. What's being argued before the Supreme Court, what the Supreme Court is considering is, does the wedding website designer, 303 Creative, have a free speech right under the First Amendment to not be forced by Colorado law to serve same-sex couples the thing that she serves to the public, which is wedding websites. Well, she says she will serve to the public, wedding websites. Does the free speech clause of the First Amendment override Colorado's ability to have a law that says, if you have a business that makes wedding websites, you have to offer them equally to same-sex couples and hetero couples. Like, they don't allow businesses that are open to the public, Colorado, to discriminate on the basis of sexual orientation. And so the wedding website designer is arguing her free speech right trumps that law. And so that's why Justice Sotomayor is going down this road. She's saying, right, but who's the one doing the speaking when you make a wedding website for a couple? Because the speech that the wedding website is saying I can't be forced to make is, this wedding is a thing, right? Like, I thought it was so notable, and by notable I mean gross, that Wagner, arguing for the wedding website designer, kept saying she can't be made to acknowledge a marriage that she thinks is false. She kept using the word false. These marriages are false to her. That's her belief. And so by putting her, her website company behind an invitation to celebrate a wedding that she thinks is false, she's being forced to speak in that way. And Justice Sotomayor obviously is not buying that there is a nexus between the business owner and the speech that's being put out in the world. And there's a big divide on the bench about whether or not this connection is bogus.
Yeah, and I really just think that no one is looking at a wedding website. You know, I'm 25. I am at the age where all of my friends are getting married. So in the past couple of years, I've been on a lot of wedding websites.
Right.
And at no point have I ever thought, wow, Zola.com is inviting me to my best friend's wedding. Like, it's absolutely ridiculous that anyone would ever think that.
Right.
I also remember they kept going back and forth between the distinction of like a fully custom website and a plug and play where you just put in your own words, as if that is a huge difference. But I also have a lot of friends who are graphic designers who do this kind of work. And no one is from scratch redoing a website every single time. There isn't a real distinction between
it's who's doing the plugging and the playing.
Yeah.
I hired a designer, or I'm doing plug and play myself because
so
it's
like
free online.
A ghostwriter or someone writing a press release, you know, those are people who are generally redoing that from some level of scratch every time. But it's apples and oranges. Yeah, they're both fruit, but they're not the same thing.
Yeah. So you're saying you don't view this as on par with Michelangelo being commissioned to paint a fresco, as was maybe alluded to in oral arguments?
Yeah, that was a weird aside that I was like, and I think it also comes down to the question of who is an artist, what is an artist, what is expression, you know. There's the idea, is a Subway sandwich artist an artist? You know, you can label things what you want, but there's a difference in terms of expression and what you are being asked to express. And so I think it's really, really different, and you just can't compare them.
Right. It's an important point. And I mean, I think Justice Sotomayor continued to press this point, and she wasn't the only one, of this is not your speech. So you don't have a First Amendment right when it comes to, you know, selling these wares to people because you don't have an interest in the speech. Pat, what do you think?
Yeah, I think, I mean, Liz, you explained this beautifully, so thank you so much for, you know, sharing it with our audience. But I think she's getting at a couple of things with this line of questioning, you know, one being that I would say the lack of content. You know, when we looked at that page, it's like an invite, you know, it's date, time, come see us. And I think Sotomayor in part is getting at, she's not saying, God and I bless this marriage, everyone, right? Like, this is not, the compelled speech argument is a little bit thin from the get-go if we kind of look at what does the proposed website even look like. And then we get into some of the issues I think that, you know, Liz, you and Kat have addressed. So I was kind of honed into that in part because we wrote about part of this in our brief as we said, hey, there are off-the-shelf products. Go look at the not.com and see what people's web pages are. They're like, come to our wedding, it's this date, here's where the gift registry is. You know, it's that kind of information. It's not a book describing what love is as the Bible would see it or as what a secular person would see it. It's pretty much information that guests need to know, is what this typically is. So I think that was a helpful starting point for the argument.
And honestly, it's uniquely first person in terms of like the actual product that you're like creating, right? Like, because as we all have been to so many of these wedding websites, it is uniquely like, here's how we met, and here's our story, and here's like 80 selfies of us, and here's, you know, it's just like, it's all about the couple, and it's uniquely first person. And even if there's some level of like involvement that a graphic designer has in presenting it, it's really a leap to say, you are speaking here through us in some way. So, Kat, do you want to set up the second clip? I think we want to do a little more Justice Sotomayor points before we get to the infuriating part.
So Justice Sotomayor also pressed the attorney for 303 Creative about other forms of discrimination. We do have a clip of that.
Where's the line? I choose to serve whom I want if I disagree with their personal characteristics like race or disability. I can choose not to sell to those people?
Not
This
at-
website? Because
No.
it's my speech?
Not at all, Your Honor. The Hurley framework provides that in a public accommodation context, the first thing the court looks at is the speech creator otherwise serving those in the protected class and expressing other messages? In the context of race, it's highly unlikely that anyone would be serving Black Americans in other capacities, but only refusing to do so in an interracial marriage context.
This is
Yeah.
rich.
Yeah. So what we saw there was really looking at what the further implications of this are. So you're not just looking at, is this same-sex couples? You're also looking at disability. You are looking at race. You are looking at all of the various protected classes that the law has for a long time recognized are at risk for discrimination, need to be protected. And so, Sotomayor asks this question, what does this open us up to? And we get told, oh, well, that'll never happen. But historically, we know this, and we went into it, they went into it a little bit in the argument where they were talking about different menus for different people in cases where historically restaurants, for example, would go in and they would say, oh, well, we will serve Black customers, but they have to go to the takeout window, or they only get a limited menu.
Right.
And so I think that's really the most apt analogy here is this is different menus. And if this goes through, that is what we are creating, is a system where people can have different menus for, the people they agree with, and then different menus for marginalized communities.
Right. So what Justice Sotomayor was asking in that question, like Kat just framed, is, so the Colorado law that we're talking about here says businesses open to the public, something of this sort, I'm not quoting, but public accommodations, businesses that provide goods and services to the public, cannot discriminate between customers on the following basis: race, religion, sex, sexual orientation, disability, and more. So what Sotomayor is asking is, if you have a free speech right to be exempted from that law when it comes to providing wedding websites to same-sex couples, how does a person who has a religious or conscience-based objection to providing a service to a interracial couple, how is that distinguishable? And her answer was, well, I took the subtext to be, it's not really distinguishable, but practically, it probably won't happen because not a lot of racists are going to serve Black people somewhat, but not in regards to marriage like I do. See, her big claim to being different from racism is that I have many same-sex customers and I will serve them like anything that I do. I will do a graphic design for their business, or I will make them a wedding website that they want to buy for their straight kids' wedding. But I just won't sell them a same-sex wedding website. So that's different than, probably someone that wants to discriminate against interracial couples are not very likely to serve Black customers in other capacities. So you could nab them for that, and that won't look like what I'm saying. And what Kat is saying, which is what other justices pointed out, is no, that's exactly what racist business owners argued during the first civil rights movement when these laws were initially passed, is that, well, actually, we want to be able to offer different goods and services based on race. We're not doing a total, we don't serve on the basis of race. Limited menus, not dining in, that type of thing is universally known to have been the argument for why conscience-based objections to these same laws, but on the basis of race, should be okay. And courts didn't buy that at the time, but we have a different court.
And I think it's also worth noting, just kind of on that very similar line, that, and I read this in some of the briefing, ADF was trying to point out, well, there are other places that same-sex couples can go to get wedding websites. And they pointed out in the briefing, the state of Colorado pointed out that has never been an acceptable answer. Separate but equal has never been an acceptable answer. They pointed to the fact that Black Americans historically have shared lists of, hotels, restaurants, where is safe, where is not safe. Sundown towns were an extreme historical phenomenon for that exact reason. Just because some places are safe and some places are not has never been acceptable. And it's wild to me that anyone is trying to argue this in 2022.
Right, we're here again. And that's because the whole purpose behind anti-discrimination laws is not because there weren't enough restaurants for Black people to go to. It's because the dignitary harm of being turned away on the basis of your race is something we decided as a society we do not want to stand for. And we also decided, Colorado at least, as a state, we want to extend that protection to our citizens on the basis of sexual orientation. And it's the dignitary harm from being told, no, we don't make that product for couples like you. That is the harm we're trying to address. Not like, oh, we noticed there aren't enough places to get your wedding website, so we're going to enact this law. It's not about availability. Like, it's not enough to say, well, there are other places that will serve you, so it's Denver. Like, you're fine. That is no answer to the purpose behind these laws. Like, Colorado has the right to enact laws for this interest, state interest, in protecting the dignitary harm or the dignity of its citizens. And that's what the court is just pretending that they don't understand, even though we've been down this road, you know, decades on decades ago. So I wanted to just mention, because, well, two things. You mentioned ADF, and I just want to say ADF stands for Alliance Defending Freedom. It's important to identify the villains. They are a conservative Christian legal outfit that is defending the petitioner in this case, and that basically makes it its mission to find these types of cases that are meant to move through the courts and roll back protections for LGBTQ Americans. That's basically their mission. So we know this case is also kind of a follow-up to the Masterpiece Cake Shop case from 2018, which obviously we talked a lot about at the time. And it came up quite a few times during oral arguments. And one notable point, when Justice Alito wanted to discuss the forms of discrimination that are done by honorable people, let's listen to the clip about that.
In light of what Justice Kennedy wrote in Obergefell about honorable people who object to same-sex marriage, do you think it's fair to equate opposition to same-sex marriage with opposition to interracial marriage?
Yes, because in how the law applies, not in discussion with folks, because of course honorable people have different views on this issue. But I think when you look at what Justice Kennedy said there, the way to honor that requirement is, as this court has set forth in Fulton, in Masterpiece, of having a rigorous interrogation to make sure that there are neutral and generally applicable laws applied in fact that way, that don't single out religion. And then the very next sentence of what Justice Kennedy said in Obergefell talked about when it transformed that honest and decent disagreement transformed into enacted law and policy, the necessary consequences to put the imprimatur of the state on that exclusion. And I think if this court were to say that the imprimatur of this court would allow a web designer to say no same-sex people allowed, or allow a school photographer to say no pictures of...
Do you think Justice Kennedy would have said that that it's honorable to discriminate on the basis of race?
No, I don't think so.
Oh, I hated that so much. And so let's unpack. Let's unpack what was happening there. And we could talk about what we all thought of that answer given by the attorney for Colorado, but I just want to do a little unpacking of what's happening there. And I said this to both of you in more colorful language while we were listening to the oral arguments, but the whole decent and honorable persons can disagree about same-sex marriage is language that was written by Justice Kennedy in the Obergefell opinion, which made same-sex marriage legal for all Americans under the 14th Amendment. And it was dicta, in other words, language in the opinion that was not relevant to the outcome, but was Kennedy just being like, oh, shucks, it's really too bad that I have to say this, but the 14th Amendment gives same-sex couples the right to marry. And I know all the people that are mad about that are still probably decent and honorable people, but, you know, we got to do what we got to do. So the justices currently on the court, the conservative justices, just absolutely love to quote that decent and honorable language to make some point that is ancillary to the legal issue in the case when it comes to these LGBTQ protections cases. And that's what Alito is doing here. He's saying, what about the decent and honorable question? Do you think Justice Kennedy would, when he said decent and honorable people can like be against same-sex marriage, like what would he think about you equating that with, you know, racist actions and that sort of thing, which is a really dumb question that like my 7-year-old like kid would frame. It's like, do you think Justice Kennedy would have said racists are decent and honorable? No? Checkmate. You know, it's like very stupid. But Colorado attorney giving his best answer, which I thought was great, which is, well, we're not talking about the decent and honorable people and their intentions. We're talking about, can the state of Colorado refuse to take that decent and honorable position and instead adopt this other state interest and embody it in its law? What did you think about that answer?
I have a lot of sympathy for the attorney from Colorado because,
right,
man, he was walking into what I'm sure he knew was not a friendly environment. And I think that question of, well, do you think Justice Kennedy would say that racists are good people? Not a relevant question. There's no no good way to answer that. You know, like,
also, who cares?
Yeah, if we're going with, you know, my fruit comparisons from earlier, we're no longer in apples and oranges with, you know, racism and homophobia and transphobia. Now we're into like Granny Smith versus, you know, Red Delicious. People have lots of opinions on those apples.
Right.
And they have different opinions, and they can like one and not like the other. So while they're analogous, they're still two different things. I know people who aren't racist who are homophobic. I know people who aren't homophobic who are racist. I know, you know, it's, you know, a fun little mix and match of prejudice. And so to even ask that question and be like, well, aren't these the same or different? And it completely ignores, you know, a ton of history and politics and sociology and psychology and just boils it down to, well, these are the same. These are the same, and therefore people should get to do whatever they want.
Oh, I know. And I love how Alito's like screed in dissent of the Obergefell decision. It's like, this is a decision of your court. It's like we're talking about Justice Kennedy as though he's like George Washington. It's like, you think Kennedy would have said? It's like, bro, you didn't agree with Kennedy. Like, let's just not. Pat, how much did you love that exchange?
Oh, I mean, I hated it. I don't. Because it fit into the theme of the day, and a theme we've actually heard in some of the other cases that the Supreme Court's taken in recent years about why is it okay to discriminate against LGBTQ people? That's okay, but we all agree racism is bad and you can't discriminate based on race. Like, they're doing everything they can to distinguish between these things. But I don't think that will work in a case like this, which is, by the way, a free speech case. So we don't necessarily, you can have people who want to say really bad things, but this court is going to say, well, you have the right to do it now. If there's in any way a shred of creative content to it or speech to it, we're going to give you a pass. And so it was a bad question just because it's like, it's almost too humorous. What would this retired Supreme Court justice say? Would he say that people are good and honorable who are racist? If you ask that question in the 1960s, some people would probably have a different perspective. We're coming to this from the perspective of gay marriage was just legalized, you know, several years ago, according to the Supreme Court. So now the court, in trying to quell, I guess, the reaction to that, you have dicta from a Supreme Court justice trying to quell that. And I don't think he's saying that the discrimination is good and honorable. He's saying, hey, maybe there's people that aren't bad people. But the way that Alito's talking about it, I think he's saying, like, hey, we think that people who discriminate against gay people, they're good and honorable. But you know, people who discriminate on the basis of race, they wouldn't be good and honorable. So the question really bothered me a lot, and I'm not fully unpacking it. Like, I'm still trying to understand. But the theme being, they wanted to distinguish between racism and discrimination against LGBTQ people. That was the conservative goal in a lot of this argument.
But it honestly can't be done. And you pointed out, Patrick, again, for the record, that this is a free speech case. So the court's being asked to decide if this implicates the creator, the website creator's speech. And if so, the government can't force her to say anything that she doesn't agree with. It doesn't really matter. I mean, I do think we're going to hear about how doubly protected the speech is in the opinion because of the religious character and because it implicates other rights. But I do think it's important to note that, like, we're not talking about just religious-based objections. We're talking about anything that the business owner could credibly describe as their speech. So like Pat says, anything creative, wedding photographers and florists and bakers, as we saw, was being argued in 2018 and wasn't really resolved by the court whether that was speech. Website creators, stationers that, is that what you call stationary?
Yeah, stationists.
People that make wedding invitations, printers, who knows? All the things where you can argue that there's a creative input by the business owner and therefore that product represents in some way their speech, it's implicated. So it's in no way is this cabined to discrimination on the basis of sexual orientation, that good and honorable type of discrimination that Justice Alito is talking about. So it's really just troubling that this was uttered by one of our highest justices in the land.
And there was another part of the argument that I think we should discuss, which kind of gets into the speech issues. And specifically, I think Justice Gorsuch, who was maybe surprisingly one of the most strongly on the side of the business owner in this case, in terms of just how his reaction to answers. And so we have an exchange with the Colorado attorney and Justice Gorsuch that gets into the religion and speech and how those interact.
The company has chosen to say they want to provide wedding websites generally, and they will not provide
all manner of websites. This individual will provide all manner of websites, just not one that requires her to write something, words on a page, customizable, all the stuff you stipulated to, that celebrate a particular thing that she finds offends her religious beliefs. I'm looking for the distinction between the two cases. One you say is okay, the other one not okay.
Because the company, unlike our first example of the speechwriter, the company here says in no uncertain terms will they ever sell a product or a service to a same-sex couple.
No, what they say is we will not sell to anyone, a message that I disagree with as a matter of religious faith, just as a speechwriter says, or the press release writer, the freelance writer says, I will not sell to anyone a speech that offends my religious beliefs.
But here, they are defining their service by excluding someone based on their...
That's their religious belief.
We have another clip by Gorsuch that we're going to talk about in a second. And that's what I thought was coming, so let me reframe. So this showcases, I think, the sleight of hand that is trying to be done by the conservative justices and the petitioner and ADF and the people that are making this push to roll back LGBTQ protections. And the sleight of hand is this. It is that we are just going to kind of argue our way out of the fact that by saying, I don't provide wedding websites that represent a same-sex wedding couple's wedding, that doesn't mean that I turn away same-sex customers, right? Like, I'm defining the service or the product in a way that violates the law, right? Like, it excludes same-sex couples just by its nature, because if you're a same-sex couple and you want a website, you don't get one. But if you're a heterosexual couple and you want a website, you do get one, a wedding website. And so leaving aside that I will sell you all the other wares, but not the wedding websites, okay, so that's one argument. But the other argument is, no, I won't sell anyone your same-sex wedding website. So your mom can't buy it from me, you can't buy it from me, nobody can buy it from me. It's not your sexual orientation that is stopping me from selling it to you. It's just the fact that, your evil wedding and your face will be on it. It's just like this attempt to muddle the distinction between what the service is and the denial of service itself. And these justices either pretend or are genuinely buying into that muddling and making that case in their questioning at oral argument. And you see the attorney for Colorado kind of struggling with how to parse, no, they are defining the service in a way that still has this same discriminatory effect. And that also is not okay. And I'm wondering what your thoughts are on this problem, because I think it makes it really hard. It's like arguing past each other, right?
Yeah, well, I think it's because people are taking two different approaches. There's the one, in my mind, sensical approach, which is you can't separate status from service in these kinds of situations.
Right.
It's the whole idea of a tax on yarmulkes is a tax on Jewish people. It's the same idea. If you are going to say, oh, well, I just don't do same-sex wedding websites, but the only people who are requesting same-sex wedding websites are same-sex couples.
Right.
There is no way to divorce those two ideas. And for some reason, whatever reason, they really want to make it seem like it is possible to divorce these two things. And it's simply not. And so I think that's really the struggle that Colorado has in trying to argue this to a Supreme Court that has framed in their minds somehow that you can separate the two things. Because there is no way, because it makes no sense to do that.
Right, right. And this has been done before, right? Other justices pointed this out. I can't remember if it was Justice Kagan or Sotomayor or Brown Jackson, who was delightful to behold, because I haven't heard an argument with her yet, but who was making this point. There are certain goods and services where the status of the customer is so tied up in the provision of the service that that they can't be separated. Defining the service in such a way is itself a violation of the anti-discrimination law, the spirit or the letter of the law. So that is a known way in which these laws operate, but it's something that the other side has kind of glommed onto and is just pushing to the nth degree in these arguments and in briefing and in the public discussion of these cases to muddy the water and make it seem like something that it's not. We don't have the re-education clip, Patrick, but we thought we did. But I just want to touch on another quote by Justice Gorsuch. We don't have the clip, but it was really important because it was like his mask slipped off for a second there. I'm a normal, respectable Supreme Court justice who totally deserves to be here, slipped down, and it was like, I watch Fox News all day, and I am crazy with a crazy agenda. And it was this point where he was discussing the Masterpiece Cake Shop plaintiff from 4 years ago, and the fact that in the course of that bakery owner violating the law, one of the things the state of Colorado asked him to do in how they enforce the law is you watch a video about what the law is and what the dignitary harm is and why we have this law and how to follow the law. And Justice Gorsuch was referring to that as a re-education program. And didn't the state of Colorado make, Jack the Baker go through this re-education program and was just it was crazy because it was just a talking point of the ADF, the far conservative Christian right, the way that they talk about these cases in their fundraising letters type of language. It was just out there. What did you guys make of the re-education program?
Yeah, so I want to point out that language came directly from ADF. They, throughout their press on all of this, and since Masterpiece Cake Shop, have been saying, re-education program. Colorado is running some woke gulag in Denver.
Exactly.
Which is absurd. That's not happening. Look, we've all sat through kind of cringy, maybe a little boring diversity trainings in our lives. I would not describe that as a gulag or a re-education training. And so it's really alarming to see this kind of language be adopted. This, in terms of like an enforcement structure, is really common for a lot of things. It's a pretty soft form of enforcement. You know, no one is calling driver's education re-education after you get too many speeding tickets or whatever. I can't drive. Or, you know, no one is calling in child custody cases when parents have to go to parenting classes. No one is calling that re-education. This is a very specific rhetorical tool that is being used by the far right to make it sound like very basic, very soft. I hesitate to even call it a penalty.
Oh, of course.
You know, just something we do for everything is somehow, you know, a sign that the liberals are taking over. You know, it was so scary
alarming
to see a Supreme Court justice.
It was really just
that.
a big flag for like, whoa, you listen to these arguments and it's like, you hear how extreme the court really is. Like, it really is a extreme, partisan, hardcore group of radical right justices. And it's not just people like us saying that. I mean, it's like, look at the things that they're saying and the arguments that they're latching onto and making. You know, this isn't just like I'm asking a question about how Colorado's enforcing this. I am using this inflammatory language that's coming directly from the playbook of one side of this dispute. It is concerning.
And I will give credit to the attorney for Colorado, forcefully said, no, that's not correct. And I think he basically said this is educating what's required by Colorado law. So we don't know what the content of this is, but
right.
I thought that's not easy to do as an attorney, to sit in front of a judge and say, no, you're wrong, no, you're wrong.
Yeah.
But he did that twice, I think, because Gorsuch wouldn't drop it.
It was a moment.
I do think that
you're
was
right.
great.
It was a moment where in the clip, and I'm sorry we're acting it out. I wish we had it because we're not doing it justice. But it was a moment where Justice Gorsuch was like pressing it, and the attorney was saying, it was not a re-education program, but here's what it was, what Kat just described. He was asked to, you know, watch a video or attend a training about how the law operates.
I looked into it this morning, and he and his staff had to attend a training.
Right, attend a training about the anti-discrimination law and how to comply. And Justice Gorsuch said, so I think you'd be forgiven for calling that a re-education program. And the attorney for Colorado flat out said, Justice Gorsuch, I disagree. And it was really jarring and powerful, but alarming, a really, really crazy exchange. I mean, I felt like the subtext was, your mask is slipping. You need to move on. It was a lot. So we've talked a lot about this. We're going long. We could process this all day, as we know. I want to get to, how do we think this case is going to turn out? How narrow might the decision be? We already talked about it's going to be or should be on free speech grounds. What do we see coming down?
I'm not super optimistic. I think that this summer, when we see this decision come out, we are going to see them side with 303 Creative. I think at best they might try to do some hand-waving hoodwinkery and be like, well, 303 is just not a public accommodation. And they might try and do that, I think, maybe, but I'm not feeling great. To quote a good friend of mine, I feel bad, not good.
Yeah, bad, not good is...
I mean, the writing's on the wall because they took this case. It's going to be, 303 Creative would win. I hope that they do this, but it's going to take a magic trick to somehow say this only applies in situations like this and not to a lot of other situations. Or what we know ADF will do and the other groups will do is, once this decision's in hand, now let's press the next issue, which isn't just weddings. Now it's just going to be service to gay people in general, or whatever their next fights are going to be, they're going to take it and run with it. So my hope is that this can be fairly narrow, because I don't know that the justices want it to be wide open. They want to allow discrimination against same-sex couples, but how are they going to draw that line? It's going to take a magic trick to somehow do that in a way that makes any sense.
Yeah, it's scary because there's no obvious way that I envision this opinion coming down that doesn't completely explode, as has been the trend with this current court, that doesn't completely explode like decades of how we understand anti-discrimination laws and and free speech law and how they interact. So it's, with Masterpiece in 2018, that court kind of sidestepped the issue and chose to side with the baker, if anyone recalls this, by saying he was treated so poorly and the way that he went through this, the way that Colorado enforced this against him violated his free exercise rights, but the law itself and the fact that it can be enforced in this situation, we're not saying anything about that. And so I think it managed to sidestep the issue that now we're seeing here. It's not going to do that again. I don't see how it could credibly do that in this case. And this is a different court. This is a way more extreme court than we had 4 years ago. So bad, not good. There's a couple questions here, and I know it's running late, but I'm just going to throw them out there and see if you guys have any opinions. Patrick, this might be good for you if you're familiar with other amicus briefs in the case. Were there any surprises in the amicus briefs for 303? Anything noteworthy that comes to mind?
were. I think the frustration I had in reading them is you have some of the academics, I think some of the law professors, maybe almost buying into the idea that that this was a legitimate case. Like that this was, we can't force people to say things they don't want to say. That is a First Amendment principle that makes sense. It doesn't make sense when it's completely made up here. You had a ton of briefs on the other side because there's these religious organizations that are well funded. Nothing all that surprising there. I mean, the thing that I would worry about is a lot of them want to press being complicit in a same-sex wedding. And that would apply to somebody providing like chairs or, just catering or anything like that. So what the other amicus are pushing for is, well, I can't do anything related to a same-sex wedding, even if it's not speech-related. So I think that was something that was really being pushed by the other side. I think our side is very timid because we know this court is there and we're trying to defend civil rights laws. So I didn't see anything there that was too surprising, but I think that there were good briefs on our side.
Yeah. I think it's also, and this, I'll read this second question here from Flynn. Is this the first step or an early step in the process of stripping away rights like same-sex marriage or interracial marriage? What can be done to protect these rights if this keeps happening? And of course, we saw gross foreshadowing by Justice Thomas last summer in the Dobbs case about how we should revisit all these substantive due process rights like marriage equality and interracial marriage, and all of these things may or may not have a constitutional basis. And for sure, this crusade to undermine LGBTQ protections in our civil rights laws, it's not a coincidence that this is coming up in the wedding industry context. I mean, this is another way of saying, damn it, we lost the marriage equality battle. How else can we undermine same-sex marriage? I mean, 100% that's what's happening in these cases. And so it's an indirect way of continuing to have LGBTQ discrimination and second-class citizen status enshrined in our laws. But it's of a piece, I think, with that crusade. And one of the things Patrick just said about the amicus briefs kind of made me think of this as well, which is, I'm blanking. Go ahead, take over.
I mean, I think
the thing
I think the thing I was going to say to that point in terms of like what we can do and where we're at is that, so we've gotten some steps in terms of protecting same-sex marriage equality, things like that. The Respect for Marriage Act, even though it does not go so far as to fully enshrine Obergefell, it does not legalize same-sex marriage in states, if Obergefell is overturned, states that had bans prior to Obergefell, those bans will go back into place, just like how we've seen with Dobbs and abortion bans. It will be very similar to that. And so really pushing both on the federal level, pushing your elected representatives to further enshrine Obergefell, and more importantly, I think at this point, talk to your state representatives. Those are the people who are going to be enshrining those protections on the state level, and if that's the direction the Supreme Court wants to push this fight, then that's where we need to push the fight, is on the state level. So right. I think in terms of these protections and thinking about same-sex marriage equality, and then also thinking further into trans rights issues that we're seeing, really the best thing any person can do right now is vote and stay in contact with their elected officials.
Right. Good advice. And I just remembered what came to mind when Patrick was talking earlier about amicus briefs and the wedding industry business proprietors who do not want to be complicit in same-sex weddings. I mean, that is where you really see that this is a total just charade for, I'm really mad about societal acceptance of same-sex marriage and the fact that that has been enshrined in our constitutional order. And so this is the only power that I have to push back against it. Because, I mean, remember that we're talking about businesses, right? We're talking about like someone who went into business renting event planning items, right? Like if you don't want to be involved in like a whole section of weddings, you probably shouldn't be in the event like chairs provision business, right? Like you always have that freedom too to like not be in the wedding industry as a business proprietor.
At some point, this particular contingent of religious folks, I feel like need to realize that they are responsible for their own religious practices.
Right. Right. I mean, because remember what we're talking about here are anti-discrimination laws that apply to public accommodations, i.e. businesses open to the public that provide goods and services to the public. Like you're not making this speech because you're just like an artist, free, just like out there putting your stuff into the world. You're a business provider. Like, don't be in the wedding industry. You always have that freedom. Like, if you don't like the way weddings are now in our society, you don't have to work in the wedding industry. So that's just a tip, free advice. Pat, any final thoughts?
No, I think you guys have done a great job on this. I'm fearful of when this decision comes down, what the next fights will be and what this also might apply to, because as an organization, we support the Non-Discrimination Act. I don't want to see religious people being discriminated against by businesses. Is that where this will lead? Like, I think this is really opening a potential problem area that we so far have not had, and it's going to create a whole new area of litigation over who can discriminate and on what basis.
Yeah. And it's taking something that's really great and like a crowning achievement of our growth as a nation, our civil rights laws, and just completely decimating it and turning back the clock like this court is determined to do in so many other areas. So that's unfortunate, but we will be here covering whatever happens. This opinion is likely to come down next summer, right, June-ish, and so we'll talk more about it when the opinion comes down. But that concludes Ask an Atheist for this week. So thank you so much for joining us. Be sure to check out FFRF's broadcast TV program. It's Free Thought Matters. Our guest this week is Amy Hagstrom Miller, the founder and president of abortion provider Whole Women's Health. In this preview, she's talking about the new landscape for abortion care in Texas in the wake of SB 8.
We have a clinic in Minnesota. We're seeing a lot of people coming from Wisconsin into Minnesota, and we are still answering all of our phones from Texas. And so we have hundreds of people still calling us, many of whom don't know abortion is no longer available in Texas. And it's heartbreaking for our clinic staff to answer those phone calls and no longer be able to help them in Texas and be sort of turned into these travel agents kind of trying to help them get the care outside of the state. Our commitment remains, even though our ability to help people has changed. Now it's funding people's travel, helping them understand where they can go. But it is a huge impact on people's families, on communities. It's going to have a long-term impact on maternal mortality, on the foster care system, the education system, for decades to come.
Watch Free Thought Matters on TV stations around the U.S. on Sunday mornings or on FFRF's YouTube and Facebook channels.
And check out Free Thought Radio, FFRF's weekly radio show and podcast. To find out where to hear Free Thought Radio, visit ffrf.org/radio.
Speaking of podcasts, if you want more state-church separation talk from the perspective of 4 women attorneys in the secular movement, including me, check out the We Dissent podcast anywhere you get podcasts. We will cover the 303 case and the push to undermine LGBTQ rights in our January episode. And in our latest episode, which drops next week, we discuss what to expect from state legislatures in 2023. We Dissent podcast. Check it out. And if you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. See you next time on Ask an Atheist.